Good afternoon, everybody. Thank you for joining us. I'm delighted to have our speaker, Joan Bibelhausen, back with us. Joan has come and presented CLEs for us many times in the past. So some of you might know her, but for those of you that don't, Joan Bibelhausen is the Executive Director of Lawyers Concern for Lawyers. She received her JD from the University of Minnesota and is licensed to practice in Minnesota. She has significant additional training in the areas of counseling, mental health and addiction, diversity, employment issues, and management. She's spent more than 20 years working with lawyers who are at crossroads because of mental illness, addiction concerns, as well as life-work balance issues, stress, and other related issues. So today she'll be talking with us about how to help attorneys who are in crisis. Please help me welcome Joan.
Thanks, Liz, and I'm absolutely delighted to be here. And hello to those of you who cannot see me because of the setup of the room. So if I know there's one chair over here and a couple up further, if that matters to you. So if you have any difficulty hearing me, please raise your hand. And I'll try to speak up or with the mic or something like that. Hello also to those of you who are watching remotely, and I assume there's a way to ask questions that you've already been told about, and so I encourage you to do that if you have questions. So today, let's see, I have a clicker, here we go, right where I was told it would be. Today this is an ethics program, and so why is this an ethics issue? Well, it's an ethics issue because it has to do with our role if we are impaired, it has to do with our role if a colleague is impaired, and it has to do with our role if someone we supervise is impaired. Now, many of you, and I know those watching remotely, are at the beginnings of your careers. And so the idea that you might be in a supervisory position is like it's not there yet. But I want you to reverse it, because what we have been seeing as my generation starts to enter into the greater risk for cognitive impairment age, we're seeing newer attorneys coming in and seeing behaviors and seeing things that have kind of just been not noticed so much by the colleagues. But as a new person watching a situation for the first time, you say, you know, this may not be right. And so as a newer attorney, you may find yourself as the one who calls attention to something that has been so gradually that those who see it all the time aren't as familiar. So that's why I think that hopefully this topic will be relevant to everybody. So we're going to talk about how do you recognize issues, what kinds of help are available, how do you offer help, what some of the concerns might be that you need to be aware of, both for yourself and down the road. So I'm going to start out with just some information about kind of what we're looking at on the national level. When we look at substance use issues, and these figures really haven't changed from year to year, about 1 in 12 of the adults have some sort of substance issue that is recognized by SAMHSA, which is the National Survey on Drug Use. It's the National Survey on Drug Use and Health that's put on by SAMHSA, which is the Substance Abuse and Mental Health Services Administration of the federal government. And 1 in 5 had what might be considered some sort of mental health issue in the last year. 10 million had serious mental health issues. So in other words, needing some sort of treatment in order for the person to continue functioning. And quite a few people had both. When we look in our profession, lawyers are twice as likely to have a problem with alcohol as the rest of the population. Women, our rates are lower, but we tend to be in worse shape by the time we get help. And that's the same thing for anybody from any other underrepresented group, where anybody who feels that they're under a microscope is going to try and hold it together in the public eye. And so people might get help later on. Now, just over a year ago, a study was published that was a collaboration between the American Bar Association Commission on Lawyer Assistance Programs and the Hazelden Betty Ford Foundation right up here in Center City. And they looked at lawyers from around the country, including members of the Hennepin and Ramsey County bars were surveyed. And what they found was that 20.6, we rounded it up to 21%, met what the medical profession would consider criteria for actually alcohol use disorder. Okay, so in other words, drank at unhealthy levels. And what that means is that we are drinking more frequently, and binging more often than the rest of the population, almost to a degree of double. And that's about 1 in 5 of us. Now, does it mean we're addicts? No. But it means that whatever is going on in our lives, we are drinking more. And that's an issue, because it may be that we make decisions to protect that or to have access that might be to the detriment of our clients. And you may actually work with that kind of a person. Other things besides alcohol, it runs the gamut. Anything that's out there, the cases you're working on, the kinds of drugs that are out there, including synthetic drugs, are present in our population. Okay? Now, the most commonly misused drug, other than alcohol, among lawyers is prescription opiates. And that may change as access becomes more difficult and awareness grows. Nobody sets out expecting that they're going to become addicted to those substances, but that is the biggest issue for attorneys. My colleagues around the country in lawyer assistance programs, when surveyed about what is the most common drug second to alcohol that they see in law students, what they're coming back with is prescription stimulants, somebody else's Adderall, or making up a story so you get it. In some campuses, it's extremely common to have this study buddy. You just take it so you can stay awake and study when you do not have a diagnosis that would otherwise qualify you to receive it. And typically Adderall is a drug, and its similar drugs are used for people diagnosed with ADHD. And when you have that actual and confident diagnosis, it's a life-saving drug. It's a career-saving drug. If you don't, it's just speed. And that's the way people are using it. But we haven't seen it so much in Minnesota. In addition to drugs, there are compulsive behaviors, and they affect the legal profession. They may affect your colleagues, and they're certainly going to affect the clients that you deal with or the cases you deal with if you're clerking or working in an administrative capacity. And so the one that is recognized by the Diagnostic and Statistical Manual of the American Psychiatric Association, you may have heard of the DSM, now version 5, is a problem, it's a gambling disorder. That is new with version 5. All of these other compulsive behaviors that cause people to make life-changing, life-threatening decisions to their detriment are not recognized as compulsive, as diagnosable compulsions in their own right, even though any clinician will tell you, and any lawyer in a lot of different practice areas, that a craving to continue to engage in having an alternate identity on the internet and living through that has destroyed a marriage. Or somebody loses their job because that's all they do all day is play computer games. And of course, we also see sexual compulsivity along those lines, where it might be someone who is compulsively looking at images and things like that online. There are employment law issues about cases about that. There are certainly family law cases about that. And sometimes it turns into a criminal issue as well. So all of these kinds of things may also be present either in the people that you're working with, you're working for, or someday that you may supervise. Any comments or questions about any of the statistics on addiction or compulsion so far? Okay. Then we get on to mental health, and the older studies said, there's chairs, come on in, that we are 3.5 times as likely to experience major depression as the rest of the population. And this was a Johns Hopkins study that looked at 28 different depressions. Women, we report it more often. We talk about the kinds of things that are like symptoms of depression more often than men do. Maybe it's because we ask for direction, I don't know. But men's depression can sometimes show up more along the anger spectrum, and we don't see TV commercials about that. We see TV commercials with people kind of down and with their head in their hands. I'm going to come over here and illustrate for you guys, okay? You know what that is. You've seen it. You know what I'm talking about. We don't see commercials with people pissed off. We're not seeing that. And yet that is sometimes the way it's going to show up more in men. So men get help later than women do. All right? Another thing I want to talk about nationally is the tragedy of suicide. It was the 10th leading cause of death for everybody in 2010. All right? And 1/3 of these people had alcohol in their system. a quarter antidepressants. So they're already being treated for that. And 1 in 5 opiates. And sometimes all of those things. Every time someone attempts suicide, one person dies. Women do not die as often because our methods tend to be interruptible. Pills, carbon monoxide. Men tend to use things that are not, like guns. So men are 4 times as likely to die by suicide than women. And as we grow older, the suicide rate, starting particularly at age 65, goes up. Now, when we look at our profession, a Canadian study that was done some years ago suggested that we were 6 times as likely to die by suicide as the rest of the population. I have a theory about that, which I haven't seen published anymore, which is that we are perfectionists in our profession. Think about that. Your first year of law school, if you blow a statute of limitations, it's malpractice. You got to have a ticker system. Don't miss this, okay? And so we tend toward perfectionism. So that 1 in 25 attempt that results in a death, we're going to be much more deliberate about our plans if we decide that that is a reasonable option. And so that's why I think that's one of the reasons that we have a higher rate. We may not actually have more attempts. Stress and addiction are predictors. We have higher rates of those things. Unresolved chronic stress is the #1 predictor for depression. The stigma of asking for help. So this same ABA Hazelden study that we saw, what they found is that 28% of those who took the survey met criteria for depression at some time during their careers. 18% for a level of anxiety that is diagnosable, and 11.5% had thought about suicide. Hadn't necessarily formed a plan, but when asked the question, have you ever considered suicide? Has suicide been something you might consider? Just over 1 in 10 said yes. So that says something about our profession. That says something about stress. And a colleague of mine in the office who's got our responsibility for reaching out to the law schools and MSBA President Robin Wolpert have recently gone around to all of the law schools and talked to law students and said, look, you get to decide what the profession is going to be like. And many of you who are early on in your careers, you get to decide what this profession is going to be like as you move into positions where you start to have some decision-making authority. Not everybody can do something about the situation they're in, but as a group, this generation, which is comprising, I think it's something like something like a third of the lawyers have under 10 years of experience. It's some surprising number. There's starting to be a critical mass saying it doesn't have to be this way. The kinds of things that are creating stress in our profession, we can say no to that. Not maybe one person, but maybe a group of people who say, you know what, maybe we can do this differently. Just like technology is starting to happen, just like the partners that you report to or you will report to have learned how to use the computer, the big boxes on their desk, and now the little boxes on their desks. Those kinds of changes can happen. One other statistic that came out of that is that 23% met criteria for a level of stress during their careers that would have been debilitating, where they were not able to function. Because statistics are so much fun, I've got a couple more things. Those who were 30 and younger or in the practice 10 or fewer years had the highest rates of problems with alcohol, problems with depression. It happens in every sort of job, but newer attorneys and law firms reported the highest overall rate. So that's really where the dialogue has to happen everywhere, but knowing that the rates of distress are higher in that first 10 years and under 30 is really a call to action for those who are in that group to say, that's not okay. So any questions about any of the data? All right. So let's talk a little bit about the issues we're dealing with. When we talk about a problem with alcohol, the AMA describes this as a primary chronic disease. All right, it's something that is the illness you have. It's not something you get because of something else. And it's got consequences that relate to everything else that's going on with us. It might be the kind of environment you're in. There's certainly research that shows that people who are more isolated have a much greater likelihood of developing a problem. It has to do with genetics. It's a disease that can be progressive and fatal. It is, some of the characteristics are continuous or periodic loss of control over how much you drink. Okay? It might be an evening, once a month. It might be a period of weeks. It comes with thinking about it, not doing the other things you're supposed to do, intending to do the other things you're supposed to do, but not doing them because you drink instead. And there may be adverse consequences, but you use anyway, and you have a reason that it's all okay. So what are some of the signs that somebody might have a problem? Well, they're going to relate to how someone behaves personally. And so you just sort of have that compass about, is this reasonable? And sometimes when somebody's behavior changes little by little, you may not really see that, which is why the new person coming in will say, well, wait a minute. They just said this and they just did this and this is okay? And somebody who thinks about it will say, well, I guess if, as I step back, it's happened little by little. There was the first time that they said something inappropriate, or there was the first time that they characteristically started coming in late, or there was the first time that they asked someone to make an excuse for them, but it's been more and more regular. Sometimes you don't really recognize the change that has happened. Somebody might have gone from showing up at 7:30 to 8 o'clock to 8:30, and now you seldom see them before 9:15, that sort of thing. Is the job getting done? Partners notice when the production changes. Support staff notice when they get emergencies at the end of the day. Associates notice when there are all of a sudden piles of work and too close supervision or no supervision, very inconsistent mentoring, things like that. But the impaired lawyer may cover very well at work. And I'll tell you why that is. We need the job to pay for it. Okay? So other things may fall apart, but we need the job to pay for it. One of our volunteers, who now holds a fairly high position in the state, talked about the time, this was before they went to law school, and they came back to work one afternoon after having a long lunch, and the two owners of the company they worked with were waiting for them and said, your drinking is starting to get out of control. And you're a valued asset here, and we want you to get some help, and we've got a bed for you at St. Mary's. It's now Fairview. And when you finish, your job will be here. But if you decide not to go, you need to clean out your desk. And he said, well, of course I went voluntarily. I was going to prove I didn't have a problem. He said, on that same day, if I had gone home and my wife, the mother of my 3 young children, had said, you've got a problem. It's affecting us. We can't live this way anymore. We've got a bed for you at St. Mary's. And we'd like you to go there. We'll visit you. We'll support you. We'll come to the family program. We want you to get help. We love you. He said, I would have moved to a motel. I didn't need her to drink. That's what this looks like. And that's why the job is important, and that's why colleagues on the job can make such a difference. So when we're looking at the stages of developing a problem, use for stress. You can see that up here on the PowerPoint. Use for stress. Come on, that's what it does, right? But if you find that you can't resolve your stress without it, then it's time to take a look at whether your alcohol use is something you want to consider. Because maybe it's what you are using to shut down because of your depression. Or maybe it's what you're using to shut down because you're in an untenable work situation. You just need to get away, and it's the quickest and easiest way to do it. A lot of people, sometimes this is just college or law school, and we grow out of it. We drink heavily, and we say, okay, I'm not going to do that anymore. Sometimes people are in a very difficult situation where they're isolated, they feel alone, and then they find a more supportive environment, and the alcohol becomes way less important. They don't have the craving. Some people, however, it's like a switch goes on, and inside their brain it says, I need this. And that's where you're going to move into the later stages, and that's where work and money are going to be affected, livelihood is threatened. You've got to be pretty far along before you start doing things that affect your work. And then later on, and in your careers, depending on what you do, you may see some of these cases where people are very, very ill. And they are anxious all the time. They don't feel better when they drink. They just feel less worse. and that's their lives. And there's still a way out of it, but that's the way our profession can go too. Now, what happens with our brain is when we have this boost of anything that gives us pleasure, it could be a fine piece of art. I just traveled, and I have a piece of art in the country I was in that whenever I go there, I just need to go and be with for a while. And I need to do that. And I got to do that again about 2 weeks ago. And that gives me as much pleasure as anything I have ever done, just to be there with it. I mean, most people probably don't have that weird relationship with a piece of art, but I do. And so if you use something that's a mind-altering substance, it's going to give you this little boost. It's like, oh, that's nice. And then we return to normal. We return back to baseline. But for the person who's moving into addiction, a dependency, a craving, the brain is saying, well, wait a minute, I want to be like that all the time. That's normal. And so the brain says, you got to move all this other stuff that's in the way out of the way and just get to that. And then our brains become less capable of being able to experience the other pleasures in lives. Our children, art, sex, music, food, because the only pleasure we can really get is when we are under the influence or at the point where we know we're going to be able to have. And then it's kind of like the brain has been hijacked, and so any other mind-altering substance is going to have this effect. For lawyers, we are high functioning, okay? We are competitive overachievers, so guess what we're going to try and hide? Any problem we might have. And so we're going to do things where we don't have any public consequences. You used to drive home after a couple drinks with people. Well, you know what? It's just easier to leave your car. We'll take an Uber. It's so much easier to take Uber now, isn't it? Because it's so anonymous. And arrange things where people aren't going to notice. We're not going to be accountable for behaviors that might be noticed or in the way that might affect our work or other things. Physical appearance. A lot of times you hear about the person who's kind of falling apart and, you know, their shoes aren't shined and they got stains. It's like the person who's trying to hide an addiction is going to look better than anybody else because that's part of their goal is to, I'm going to have access to this. It's not a problem. See how good I look? They will isolate subtly. No, got to get home to the kids. Well, actually, they have to get home to drink without somebody paying attention to it. They seem to have good boundaries that way. And this is one that's pretty interesting. You know, alcohol abuse, that's when you leave something in the glass, right? It bothers people with an alcohol problem if somebody else doesn't finish their drink. It's just something that gnaws at you. So if you find yourself thinking, well, yeah, think about it. Because talking to people in recovery, they'll laugh about that. They'll say, the thing that used to really bother me is when my spouse would say, oh, you know, I don't need to finish that. You're not going to finish it? Really? You're not going to finish it? I mean, the only reason you drink is to drink as much as you can. So those are some of the things that might appear in a work setting. And in a work setting, it's important that the support staff have a safe place to go if they are concerned about a lawyer. And the same thing should be said for any kind of junior attorney staff. Ideally, family members would also know about the services that are available, such as Lawyers Concerned for Lawyers. And so we suggest that our materials be distributed with the benefits. Nobody's ever asked, but I say it every time. So when talking about these issues, there's something called the CAGE test. And so here are the questions to think about if you're concerned about yourself, or, you know, it might be a family member, it might be someone you work with, it could be someone you went to school with. So the first thing is, do you wish someone would cut down on their drinking? Or have you ever felt you should? Have you been annoyed if someone criticized or even commented on your use? Or have you bothered somebody else when you thought you were making a well-natured comment and they kind of blew up on you? Have you ever felt guilty about use or something that happened afterwards? And have you needed an eye-opener? That one tends to be more with alcohol, but that they needed an E on the CAGE test, so that one's there. So those are the questions. Any questions about substance issues? Okay, I'm going to move on more to mental health issues now. When we're looking at depression, which is the most common mental health issue among lawyers, it occurs in stages. You don't just wake up one day depressed. I mean, there may be some sort of thing that happens to somebody that can trigger almost an immediate reaction, but that's very rare. Rather, it's going to occur in stages where you don't sometimes even notice as much, but you just kind of tend to continue going downhill. And a couple of things that are really characteristic is that you lose interest in the things that usually bring you pleasure. And someone described it to me once as everything was gray, or a muted form of whatever color it was. And they said one of the ways I knew that my meds started working is I started seeing colors again. The grass was green one morning. The thing that lawyers notice is that we can't concentrate, remember, or decide as well. And that's the kind of thing colleagues may notice as well. It's not just something we can wish away. So in a colleague, you might look for a change. Because if you think about it, those of you who are familiar with the Winnie the Pooh stories, all of us know somebody who is Eeyore, right? They've just always been Eeyore, all right? But if they've become Eeyore, that's the one who's always, it's okay, I guess, I don't really need to be happy, okay. So, but if they become Eeyore, then something's going on. Some of the symptoms are, in addition to the things I already mentioned, a change in appetite, sleeping, and just going to the point where sometimes it seems like not being alive would simply be easier. Untreated depression is the #1 predictor for suicide. From the outside, well, here's our typical lawyer, right? Gloomy, pessimistic, cynical, all of these things that happen because of the ridiculous things we get exposed to that people do to each other. But the key is, has there been a change? That's when you might think about whether there's something going on. In addition to depression, we see almost the same level of anxiety that is causing people problems. A little bit of anxiety is good. Think about it. Think about when you are in the zone. Think about when you're doing your best work. You're motivated, right? You've got that extra little push of adrenaline. That's a form of anxiety. But too much anxiety, where you're not dealing with it, that becomes an ethical sinkhole. Okay, and I'll talk about that a little bit more later. And then these other mental health issues are other things that are coming to LCL among lawyers. Most particularly, as my generation ages, cognitive impairment is starting to rise. And you are going to work for people who maybe it's time that they retire, but either people haven't figured it out or they don't know how to talk to them. So as we look at mental health issues, we really need to look at how do we reduce the stigma so that people will ask for help. Because stigma is a feeling that it's disgraceful or we're afraid to ask for any help or tell anybody that something's going on. It can be experienced with a real diagnosable problem or simply just stress. And the person who has that issue is feeling ashamed or isolated. And I can tell you that this also can arise in somebody who is a colleague because they think they ought to be able to fix it somehow. We are very proud to be able to say, I can figure this out myself. And that isolation is very detrimental to us. So we can talk about this as well. People should get help. Of course they should get help. But, well, I don't need help. I mean, that's the way that's where we go. So when you hear that, you know, is there someone that comes to mind for you? It's like, geez, I wonder about them. I wonder if they're okay. I wonder if they get some help. So when we look at this study, the ABA Hazelden study, barriers to seeking help included not wanting others to find out they needed help. And it's not confidential. Now, Minnesota has the strongest confidentiality policy in the country for lawyer assistance programs, and so I like to think if we were able to get data for just Minnesota, that would be less of an issue, but they made this survey so confidential that they cannot tell the location of the computer where people answered the survey. That was one of the things that they put in place, and in fact, it was one of the requirements to participate at the level that Hazelden Betty Ford required in order to be involved on the social science level. That kind of research. So I'm going to move into the kind of more of the ethics piece of this next. And I want to know, any thoughts about this? What comes to your mind? Any questions or comments before I move on? I'll give people online a minute to ask something if they have anything. Okay. Well, what are the ethical issues? All right. Well, let's start out with the idea that you might be working for somebody who seems to have some sort of a problem. The first thing we want to do is we want to make it okay. We want to cover. We want to handle it. And sometimes I'll talk with attorneys from Minnesota Lawyers Mutual, MLM, which insures a lot of the lawyers in Minnesota for malpractice. They'll talk about the cases they've had, where they've had to pay out malpractice claims, where either a support staff member or a newer attorney who didn't understand tried to do something that they thought was just like something else without the supervision of the more seasoned attorney, and malpractice ended up being committed. So there's that tendency to say, well, I'll just cover it, I'll take care of it. And we tend to try to keep it from looking like there's a problem. Same thing happens in families with people with problems, and it happens in offices too. The person with the problem who's in denial and is a competitive overachiever is going to try to make you look bad sometimes. By, well, you just didn't do that. You didn't tell me. You did all of this stuff, but they're insisting you didn't. And it's an alternate reality, and yet that's just what's being put out there. Well, this new associate I have, they just don't have what I'm used to. Well, in fact, the lawyer isn't providing the supervision or even the information to be able to do the job. And you have to remember that you don't know what you don't know. So what do you do if you're worried about the client? Well, people can always call LCL, and we don't give legal advice, but we can talk somebody through a situation just to kind of hear yourself say it out loud and think about what you might have to do. Just having that other person, and we don't report. I'll tell you a little bit more about that in a minute. You can also call for an advisory opinion from the Office of Lawyers Professional Responsibility, but you will have to say who you are, and then they keep a record of that so that that is to protect you. You say, okay, this is something I'm being asked to do. No, you can't do that. Okay. They have a record that they told you not to do that. Well, what if the person you're working for insists that you do something? You're still going to get in trouble, but it is a resource for you. And in some cases, calling your PR professor is also an option. When we talk in the PR classes, I always look over and say, and they can call their PR professor, right? And I nod my head vigorously, and sometimes reluctantly, and sometimes very happily, the professor will nod their head back. So some of you may have seen that. Think about that. That's an option. And if you start to find yourself in a situation where it seems untenable, it's time to start thinking about protecting yourself. Because the person who is protecting an addiction is not going to be interested in advancing your career. And so it may be that you have to look at moving on. Sometimes that's just the way you have to go next. In Minnesota, when I was in law school, the person who was the director at the time thought that half of the cases that came in the office had an alcohol-related component, the Office of Lawyers Professional Responsibility. And I asked someone recently, I said, what do you think it is today? And they said, well, we don't keep statistics on it, but I would say that it's at least a third. So a half to a third, I think that's better. What happens if somebody does commit misconduct and it does rise to the level of discipline, they have a problem, either a mental health or a substance issue, they can raise a mitigating factor. And they can say, I have a problem. And that's what happened with this. And so in a probation, that might be what's going on. And so a probation related to chemical dependency may involve a requirement that somebody attend some sort of abstinence-based support. I've got AA in here just because that's quickest, but shortest, but it's not always that. And that they may have to do random testing for whatever it is they're taking. In terms of mental health issues, what we see is that probations may require a mental health treatment requirement. So you may actually be required to test to show that you are taking your meds. And you will have to have mental health professionals reporting that you are attending and continuing to make progress. They're not going to give everything about what you say, but that's part of your probation. Now, the open cases, The annual reports no longer, to my knowledge, contain this level of detail, but some general summaries from the past have suggested that almost half of the discipline cases include some level of neglect or non-communication. Is that a healthy lawyer? Not getting back to a client to the point that it rises to an open file in discipline? We all have clients that are annoying and we don't call them back as quickly as they'd like, and their emails all end with exclamation points or in capital letters and things like that. Those actually are the ones that you learn not to take in the first place. But in any event, but if it rises to the level where they actually open a file, that's not a healthy lawyer. And in one annual report, nearly a quarter of the cases involved non-cooperation, just not getting back to the board. That's not a healthy lawyer. That's the person who cannot open the mail. And so if ever in your career you are faced with a situation where you have a letter from the board and you simply cannot open it, it's time to call LCL. Because something's going on, and the longer you don't open that letter, the worse it's going to get. I just did a program yesterday with one of the attorneys from the director's office, and he talked about that. He said, we aren't going to go away, and it's only going to get worse, but if you come to us and you say, I have an issue, and that's why these things happened, we're going to work with you. Now, I'm quoting him. I'm not endorsing that. I'm just saying that's what was said. But the point is, as you're out there, you know, if you talk to a colleague who says, yeah, I got a letter from the board and I can't even open it, that is about the biggest red flag there is. Because that's your career. How much time did you spend putting into that, and yet you're not able to open the letter that might have something, that might be a summary dismissal? Because those come from the office too, but it may also say, we are opening a file, or we would like you to respond to this sort of thing. I don't think that someone where it rises to the level of being in a public petition, that is not a healthy person and they need our help. So what we see, we've got this picture here. You know, on the top we have we're not completing transactions, we're not communicating, we're missing deadlines. That's the tip of the iceberg. Down below we've got all of these issues that are going on with us. Statute of limitations, certain illnesses, anxiety, trust account issues. And this is a slide, these two slides were prepared by a colleague of mine in another state, and so I want to give credit to the Louisiana Lawyer Assistance Program. But I also want to take this opportunity to call attention to one of the words that is up here. I don't know if I have a pointer. Oops, okay. No, but it says alcohol drug abuse. Now, I made what I thought was a joke before, which was about if you leave, you know, wine in the glass, that's alcohol abuse. Are there any other illnesses where we characterize the person who has it with a term like abuser? Think about it. What about a smoker that gets lung cancer? What do we say about that? We talk about them as being a courageous person. We talk about them dealing with their cancer gracefully. We talk about all sorts of really positive things. But the person who gets a mental health issue or becomes addicted, first of all, they're an abuser. And secondly, we talk about things like crazy, unstable, unpredictable. And we need to think about that. Because the people who need help, who are ashamed, are not going to ask for it. But if we look at it as a person with a problem with alcohol. And so the DSM-5 talks about substance use disorder. And I love that because the acronym is SUDS. We call it substance misuse. We're no longer calling it substance abuse, although, you know, people in the field are still doing that. But I want to bring that to your attention. It's very easy to do a search and replace in a document and change abuse to misuse. And think about how that changes the way we look at this deadly illness. So that's why I left his words in here. Anybody got an opinion on that? Okay. So what happens with, we call these behavioral health disorders, that's one thing. What happens in the legal system? Well, first of all, the criminal justice system has gone from you are bad because you drank to you still have to pay the consequences, but maybe we're going to put you in a treatment program. Drug courts, big part of the court budget this year. The disciplinary system has some things that I'm going to go through one by one that are important in looking at when we have an issue presence. The first one is that a lawyer is not supposed to shall not represent a client or shall withdraw if the lawyer is unable physically or mentally to represent the client. So I also like to say sometimes to people who have issues, you have permission to say, I need to get some of this off of my plate. I can't handle all of this. And so that's one thing that's supposed to happen. And if you're in a collegial setting, it may be that somebody else has to help that happen. One of the comments to the diligence rule, and this is more for solos, but it says that that somebody should make a plan. Who's going to take care of your clients? Who's going to review your files? Who's going to make sure that things are handled? And see if there's a need for immediate protective action. Some states require that you list the name of an attorney, and some people just list attorneys that they've never asked. Who's going to take care of those clients if you're hit by a truck or if you have to go to treatment? That's one of the things that has to happen. The State Bar Association has a lot of resources for practitioners, and a couple of things that they have include how to all of the different things you should have in order to give, your passwords, your bank account numbers, and various other aspects of something that could be handed over to somebody in the event of your death or disability. For those who are in a supervisory role, if you have comparable managerial or authority or supervision, so in other words, you have something to say about what somebody does, you know of misconduct and you fail to take action, guess what? You can be held equally accountable. That's why when you see a situation where maybe a lawyer stole money from clients, it hits the papers, things like that. What also hits the papers is the incredible steps that the law firm has taken or the office has taken to cover things and to make sure that things are in place, because it's the right thing to do, but they can also be held accountable. Then we also have the rule 8.3. which we called the rat on your friends rule when I was in law school. I don't know if that's what's still being considered, but that's the rule. And it says if you know of significant misconduct, or you know of conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer, you shall inform the appropriate professional authority. Now that's the Lawyers Board in Minnesota. And what we will say sometimes when somebody calls us and says, I'm aware that this lawyer did this thing and I think I'm going to have to report them, and of course we can't advise them on whether they have to report them or not, but the rule does not say when. And this is one of the things when we get to talk to judges, and I don't know if some of you might be ALJs or I don't know if you'd ever be in that kind of a situation, but that's really important, because a lawyer that appears in front of any sort of judge or magistrate, etc., yes, there may arise a duty to report, but it doesn't say when. So sometimes that individual can talk to the lawyer and say, I am going to have to report you, but I'm concerned. And I'm wondering if you know about LCL, or I'm wondering if you have other resources, or I'm wondering if you have things in place. And we've coached a number of people through having that conversation. So you think about, well, great, I've called LCL, now they know about it. But 8.3c is an exception. It says that we do not have to, that anybody who is a volunteer for a lawyer assistance program, which in Minnesota is LCL, which includes the 2 lawyers on our staff, me and another, and any of our volunteers, we are not required to report. So in the course of somebody getting help, they might say, you don't understand how bad it is, I did this. It's like, okay, well, we'll help you find counsel to work through with that. Pay for it, by the way, just to make that clear. And will work with you to put some things in place so that when you do report, you can say, and here's what I'm doing so far. I mean, you can't wait too long, but we do not report. So the person can come to us safely. And a law firm can call us, or a supervisor or a colleague can call us and say, this is what I'm seeing. And you may not even know whether it's going to be something that rises to the level of reporting. I've talked to a number of lawyers over the years where they'll describe a situation to me and they'll say in the course of it, I'm going to have to report this person, aren't I? And of course we have to say, well, we can't tell you yes or no, but telling us does not change anything you have to do, and telling us does not mean that we're going to do any of it. And so that is really a safety net for people in Minnesota. And most countries, this is a model rule, ABA model rule, and most states have it. And it's something that really helps people to be able to kind of put some things in order, get the help they need, and then start dealing with what that process and those things are going to be. So let's say that somebody has a problem and they committed misconduct and they're going through the process with the board. There are mitigating and aggravating factors. Mitigating factors are things which can lessen discipline, and aggravating factors are things which can increase it. Aggravating factors might include a bad attitude, in other words, non-cooperation. It might include a history of discipline, things like that. Mitigating factors can include what somebody's career has been like, whether they've had other complaints, but it can also include if they have had a diagnosis for a problem. So the seminal cases in Minnesota are, and this is the first one, In re Johnson. This established 4 factors that need to be proven if somebody is apt to get mitigation for a disciplinary issue and they have a chemical dependency problem. First, they must be affected by it. So in other words, they have to have the diagnosis. Yes, you do have a problem with alcohol or drugs or whatever. The view on drugs has changed over the years. It used to be alcohol's legal, drugs are not, therefore we don't apply it. But in more recent cases, there's been a greater understanding that addiction is addiction. So the use has to have caused the misconduct. Think about that, because I'm going to come back to it. The person has to be in recovery. So in other words, they have to have gotten help, and there's got to be people out there that will say they're doing what they're supposed to do. Often that will mean that they've gone through a treatment program, or that they're involved with some sort of something that is going to be accepted as something more than their word for it, okay? And then the misconduct has to be not likely to recur. We have the same factors for mental health. This is the Weyrich case. Now, interestingly, Mr. Johnson, it was found to be medication. Mr. Weyrich, it was not. And these are cases from the early 80s. And I don't know if the court would be different today, but in reading the facts of the Weyrich case, I cannot see how that would not be seen as a mental health issue that caused the misconduct. But that's a long time ago, and I like to think it would be different today. I mentioned the causal connection. It's very difficult to prove. There are 2 cases, In re Minn and In re Rodriguez. Both of these individuals were disbarred. Both of them did some things they shouldn't have done. One of them had a diagnosis of significant mental health issues. The other one had a diagnosis of of addiction, substance use disorder. And both of them were disbarred because the causal connection was not found. The therapeutic community would disagree with the way the court reads it. And there, in fact, there's been a law review article that has looked at the Minnesota standard on that. But what that means is that sometimes lawyers are reluctant to raise a mitigating factor because they're concerned that it's going to be made public. You know, it's one thing to make some mistakes in your trust account. People will look at that and they'll say, yeah, I could have done that. I'm glad I caught that one mistake before it was an overdraft because I would have gotten that same letter, and then I had a little bit of a mess to clean up, and I'm glad. You know, they'll say, I could have been there. But if it's a public mental health issue because somebody has claimed mitigation, there's so much more stigma about that. So people who deserve to have that mitigating factor considered will sometimes not even bring it up. And some lawyers in the professional responsibility arena will tell them not to. And I think that's unfortunate. Now, several years ago, and I don't have this in the PowerPoint, but several years ago there was a case called In re Clark, and this lawyer was placed on disability and active status. And in one of the footnotes, it was either footnote 2 or footnote 3 in the case, the court just noted evidence of mental health issues was submitted. And we looked at it, and we agreed that there are issues. And the attorney said, please seal that. I don't want anybody to know all of this. Okay, we can do that. Our word's good enough. So the court said, we don't have to tell you everything about this person's mental health issues. And with the permission of our board, LCL I wrote on behalf of LCL a letter to the court telling them that I think that that footnote is probably going to save some lives, because I'm going to try and tell people about it. That if you have a mental health issue and it's why you did what you did and you like mitigation, you can request that the gory details not be out there. The public's right to know does not include all of that information. And so I think that that was a really, really good thing that happened in Minnesota. If somebody commits professional misconduct, it's not just going to go away. There may be mitigation. Sometimes somebody needs to step away. They need to take disability and active status, and that can be a really good thing for people. Sometimes people resist it, but it's a way to just step away and say, I need to go take care of myself for a while. And then you have to prove that you're fit to come back, but it abates the action. And then there are going to be the consequences upon reinstatement if you seek reinstatement, but at the same time, you're also going to be able to show these are all the things I've done. Probation is certainly a way that it also can be a safety net, where it might be public or private, but somebody is paying attention. Whether it's helping someone who's had issues with organizing their files, or whether it's some sort of monitoring where somebody is testing and things like that to help give them that safety, that safety net. And then we already talked about mitigation. So the rule I like best, and this is actually a comment, is the comment 2 to the rule on diligence, which says that a lawyer's workload must be controlled so that each matter can be handled competently. Think about that. Think about the permission this gives. Think about how this allows us to say, I'm going to look at what I have in front of me, and I don't feel that I am able to do the level of work that I would like to do because of what is in front of me. And we're trained to make arguments in support of a position we would like to advance. So maybe one of those arguments is to the supervising attorney to say, I looked at this ethical rule and I'm in violation. Now, inside of you, maybe 90% of you are laughing at me. Really? I'm going to be able to say that to somebody? But think about it. It gives you an extra tool if you're feeling overwhelmed. And we have talked with people who have called us just because, you know, they're really stressed out, and I'll say, well, look at this rule. How do you feel about that? And we'll have a conversation in the context of it, and they'll feel like, okay, it is okay for me to say it's too much. It is okay for me to say to myself it's too much. I mean, some of these conversations are with souls. So in the last few minutes, I want to spend a little time on what you do if you're concerned about somebody and what kinds of things you can say. So there's different levels of intervention. There's different levels of getting involved. Some of it has to be official. Okay? Other times it can just be one person talking to another, saying, I'm concerned about you. And there are things to say and not to say. Sometimes the easiest thing is just to say, are you okay? And often the person's going to push back. Yeah, I'm fine. Why? Well, you just kind of seem like you're not as something as you were. Or we finished up this big case, and in past times this has happened, and I'm not seeing that this time. I'm just kind of concerned about you. Yeah, I'm fine. So we have a volunteer who had someone talk to him that way, and he answered that way. And he said, you know, I've been depressed for a while, I was drinking too much, I really didn't know what to do about it, but I didn't, it's like, I ought to be able to fix this. And he said, I hadn't felt much for a while. And I had this overwhelming feeling come into my head, which was that I wanted him to ask again, because I wanted to change my answer. So this is Minnesota. We always ask twice, right? Hey, would you like a little lunch? No, I'm fine. Some coffee? No, no, no. Are you sure? I've got some cream. If you'd like, no, I'll take it black. You know, it's like, really? No, really, I've got cream. Well, actually, I like that better. You know, that's how we do it. So ask twice. And the next time, and this is what you learned in evidence class if you haven't practiced law yet, or in civil procedure or trial practice or any of the other classes you took, is if you don't like the answer, you come back and ask it in a different way. So you say, well, here's why I asked the question. I don't think you're okay. Here's what I'm seeing. And then you start talking about what you've seen, and you listen to what they have to say. And then have something to offer them. You want to talk about it. Do you have someone to talk to? Do you know about LCL? In a work context, that's not this seminar, but I just want to raise some things that we are talking, if you're ever in a supervisory situation or a place where an employment law context might be there, you're never going to diagnose. It's going to be about conduct, not condition. And regarding as disabled is a violation of the ADA within certain contexts that I'm not going to go into. So within a workplace, how much do certain people need to know? And the less, the better. And so if there is a work situation where somebody is going to be talked to about going on a leave of absence or something like that, it's a really, really good idea to have an employment lawyer involved in that conversation. If the firm does not have one or the office does not have one, somebody has to be there to talk about it. Sometimes when people take a leave of absence, there's going to be return to work agreements. There's going to be ways to support the person. We've worked with a lot of employers on putting that together, and sometimes there will be a last chance agreement. In other words, do what they told you when you came out of treatment, and if this conduct recurs, then we will take other steps. When we think about our clients, what's the best interest of the client? Is the best deal everything you can get? Not necessarily. And so recommending that somebody see a therapist because you're their lawyer, not their counselor, even though they talk to you about everything, can be part of really what a competent lawyer would do. And I keep talking about calling LCL. Well, here's what that means. We're free and confidential. Firms or other employers, supervisors, colleagues can call for guidance. Lawyers can call for help. We get calls from people who will say, I'm calling about a person I'm concerned about, and I really don't want to tell you who they are, who I am. It's like, okay, that's fine. If you were to talk to someone who is a mandated reporter, there are rules, but I am not. And so somebody can just explain a situation and it's like, well, what do you think about this? Or where would you like to go with this? And we will help kind of guide to that next step. We help lawyers, judges, law students, and immediate family members. We do programs like this. We have a good website. We'll talk to people who are concerned about themselves or others. We have a 24-hour hotline. We'll provide coaching on intervening on someone, either informally or formally. We do interventions. We'll refer people for various things out in the community, as well as providing group support, individual counseling, peer support. And if you are resonating with these and you're a person in recovery or someone who just gets wellness and would like to be more engaged, we have the fellowship that comes with being involved in that. And you can help other people. We have a partnership with an employee assistance program that also serves some governmental units, so you can double dip. And you get up to 4 free counseling sessions on any issue that causes stress or distress. And that includes you or your family member. So if it's a couples issue, it might be that you see someone, your spouse sees someone, and maybe you see them together a little bit. They also have a website with lots and lots of information, including how to help your kids through the loss of a pet, which is something that I just accessed for my son, as well as the very serious issues, like, you know, I'm concerned about someone who might be suicidal, or I drank so much last night I don't know what happened. And you can call them directly and not go through LCL, or you can call LCL. at the number on the screen or in the PowerPoint that you picked up. We brought brochures. They are on the outside, so I hope you grabbed one. Maybe you'll want to give it to someone else. That's why you have to take it. And I brought a few pens. They might be all gone, but if they're not, grab one of those. So I'm going to stick around in case anybody has individual questions. The email right here, help@mnlcl.org, comes directly to me. So it's a lot shorter than my name. So if you do have questions afterwards about anything I said, or you want to raise something that you don't want to say in front of other people, please contact us. We're free, we're confidential, there's someone to talk to 24 hours a day. Thank you.